This video is a project of the Annenberg Foundation Trust at Sunnyland. In the summer of 1787, delegates to the Constitutional Convention gathered in Philadelphia to create a document that would establish the government of the United States. On September 17th, that landmark document, our Constitution, was signed. In commemoration of that day, students from several California and Pennsylvania high schools were recently invited to the Supreme Court building in Washington, D.C. to meet with Justices Anthony Kennedy, Sandra Day O'Connor, and Stephen Breyer. The views of the students and the responses of the justices provided a unique glimpse into the workings of America's highest court and the document that shaped our history and guides our future.
Justices Kennedy and Breyer and I would like to thank all of you so much for making the trip to be here today and to talk about some matters pertaining to our constitutional system that are really important. And we're very glad that you've been thinking about it and studying it and that you want to have a discussion with us. And so we look forward to today, and hearty welcome to all of you.
My question is, do Supreme Court justices play a different judicial role than, say, lower federal court judges or state court judges?
Basically, as you already know, the Supreme Court is at the top of the ladder when it comes to filing appeals. And so a decision of this court cannot be appealed to a higher court.
In a large sense, they're the same. Their oath is the same, the method is the same, the authorities that they refer to, the sources of law that they refer to are the same. And their ultimate function is the same, and that is to convince the litigants that they've had a fair hearing, to resolve the case according to the law so that in the long term people will give it allegiance and loyalty. As a practical matter, this court, I think, is different in that we don't take cases until other courts are in disagreement about it, and we have to be especially careful to follow our formalities and our traditions, because we know going in that the public and the courts are divided on the cases. Maybe I haven't quite captured
that's true.
it,
I think part of what we do is the same as what other courts do, is we'll interpret statutes or we'll decide legal cases, and they do that in state courts and they do it in lower federal courts. And we have the last word, but that doesn't always mean the best word. It means someone has to have the last word. But there is one thing that I think is different, and the different thing is this, that we have a special job, different from the lower courts and different from the state courts, in that we have lots and lots of cases interpreting the Constitution of the United States. Now, they have them in lower courts too, and they have them in state courts, but they don't have that steady diet that we have. Now, why does that matter? I think it matters because after a while, each of us, anyone in our job, has to form a view of what this document, the Constitution of the United States, is really about. And I suspect if you ask the three of us and you ask the other members of the court, even though we disagree on a lot of things, they won't disagree about the basic nature of that document. And when I try to describe it, particularly people like you who know something about it, you obviously do know something about it. You say, well, what's at the heart of it? At the heart of it, we think, are institutions through which the ordinary citizen of the United States can express his will. What does he or she want in his community? It's called a law, a statute, a rule for living together. And we have a system in that Constitution where people do that democratically. There are boundaries. And at those boundaries, some of them have to do with protecting individual rights. You can't go too far. even democratically, because we're trying to protect those basic rights from tyranny. We insist on a degree of equality. We insist in this Constitution upon a rule of law. People have to follow it. And the Constitution insists on a division of power between state governments and federal governments and among three branches of the federal government. Now, those things, in a sense, are qualifications. They describe those boundaries of a democratic process. But I think when you go into it, you'll say, basically, that's what this Constitution basically does. And what do we do? I think of us as the boundary patrol. We're patrolling the boundary. When we patrol the boundary, we say whether someone else, like Congress or the President or others in the state, so forth, when they went too far. But it's one thing to patrol the boundary, and it's another thing to fill up the middle. And filling up the middle is the job of the democratic process. That's the job of you, that's the job of your parents, that's the job of your citizen, every citizen, your friends, and so forth. And that's what the Constitution sets up.
My question is, what is judicial independence and why is it important?
What is judicial independence? And that's not a very good term for today's world. I don't think most people have an immediate concept of what that means. Does it mean a judge is absolutely free to decide any issue based on the judge's own whim or desire? It does not mean that. And when the framers of the Constitution envisioned three branches of government and created a judicial branch, they went to great effort to make sure that each branch was independent of the other two in various ways. And when it came to the judicial branch, I think what the framers intended was that the judicial branch could operate and carry out its duties to interpret the Constitution and laws of the United States in ways that are fair and impartial and that follow the Constitution and laws, but without threat of retaliation against the judges if the other two branches of government somehow disagreed or were unhappy. That's what I think it's all about.
I think most people would, is suppose, unlikely in your case, but suppose you were very, very, very unpopular. You're probably quite popular. But suppose you were the least popular person in the United States. Still, if you were accused of a trial, accused of a crime and had a trial, maybe you're innocent. And you wouldn't want a judge who's deciding your case with an eye towards how popular he will be, because how popular you are might influence him. I think people can understand that, and they can sympathize with the need to give even a very unpopular person a fair trial. Why should we, the judges, make a decision about the meaning of an important law, say freedom of speech or equal protection of the laws? Who's to say that the three of us are any more honest or can do it any better than a politician? Now that doesn't have an obvious answer, but it does have an answer. I think the answer is that if you go back and look at what the Constitution is trying to do, part of what it's trying to do is to prevent a majority from tyrannizing a minority. Now, we have some pretty bad examples of that in our history. What about slavery? What about 80 years of legal segregation? What about running in and stopping people who are unpopular from speaking out against a war? There are many bad examples. And the notion of creating an independent judge who's independent because he isn't or she isn't responsive to the voters is one way of hoping that we'll be able to protect the rights of minorities that are guaranteed under the Constitution. It's only an experiment.
Here's a way for you to think about it. I call it the 3 R's. What's the reason for judicial independence? First R. Second, what are the requirements or the requisites for it? How do you structure it? 3, what are the responsibilities that it entails? The responsibilities of the judges, the responsibilities of the other branches, the responsibilities of the people. And I think we can begin with what is the reason for it. Why do you have it anyway? If you believe that there are some neutral principles, if you believe that there are some fundamental principles, if you believe that those principles can be understood and that the American people, if we're talking about America now, has a consensus about those principles, that's the beginning of the reason for judicial independence, so you can protect those basic principles.
Look at the case of Brown versus Board of Education, where it was decided that the earlier court precedents were wrong and that the Equal Protection Clause is violated when a state segregates its public schools on the basis of race. Now, this was a very big decision because there were many areas of this country where racial segregation was used in public schools. And it was a very unpopular decision in some areas, and it became more so when the orders were entered by federal courts to implement it. Troops had to be sent to Little Rock, Arkansas to enable some black children to get in the front door, if you can imagine. Very unpopular. And yet, if it's possible to impeach the judge for rendering an unpopular decision or somehow retaliate against the judges for doing that, where would we be? And that's why the framers of the Constitution went to some effort to create a judicial branch that's independent from the other two, to enable them to make important decisions.
I think the law is a check because the judges are committed by their oath not to do what they want. They are committed to do what they must. And if you don't think the law has an objective, knowable, stable substance to it, I don't think you believe in judicial independence. And we're checked in other means. We're checked by the fact that we have to give reasons for what we do. We have to justify them to our colleagues and to other courts. We have to convince the legal community, the American community, that this is right so that they will follow the law.
Well, I agree with Justice Kennedy that every judge at every level in the country takes an oath on becoming a judge to follow the law and the Constitution of the United States. And judges, by and large, take that extremely seriously. Now, any judge at a lower court level, a state court or a federal court of appeals or district court, will do the judge's best to resolve these issues, and the losing party may then appeal from that decision. And that's another check on decisions in the lower courts. They can bring it all the way to this court.
My question is, what are the most important ways in which judicial independence is protected by the Constitution?
And the Constitution only has 2, really directly. It says, you'll appoint a federal judge for life. That was Jefferson's complaint.
Actually, it says for good behavior.
All right, but
right?
Well, that may be a problem. But Jefferson complained, he said, well, the trouble with the Supreme Court is that they never retire and they rarely die. So there we are. But that's one guarantee, and the other says as a compensation it shall not be diminished. Well, Congress has figured a way around that one. They just let the inflation diminish it, and then they don't keep you up. So it's the same thing. That hasn't been too much of a check. So independence, about 15 years ago, I was in Russia, and they were talking about to the 500 judges about They were from all over Russia. You know, there's a big mix of race, religion in Russia, just like here. They came from Kamchatka. They came from, they're all over. And they were talking about how now in the new Russia they were going to be independent. There was some skepticism in the audience. The judges said, what about telephone justice? Telephone justice is the party boss tells you how to decide. Why won't that happen? And they asked me if that happened to me. I said, no. And they looked skeptical. So I said, oh, I see. You think I'd tell you no even if it were yes. They said, right. They said, who appointed you? At that time I was on the Court of Appeals. I said, President Carter. They said, well, how does he, maybe he'd call you and tell you what to do. I said, no. Well, prove it. Now I went on and pointed out how unthinkable that would be. But what it comes down to is habit, a state of mind. What is it you think you're doing as a judge? Why do we follow those laws? Well, that's the job. That's the nature of what it is to be a judge in America. It's very hard to get that into people's minds, and it takes a long time. But it's a very, very powerful force on keeping people independent and making certain that the judges follow the law.
You think about separation of powers as this beautiful little machine. There's kind of a mechanical metaphor in your mind when you think checks and balances. It's like a little clock. The Congress enacts, the president vetoes, the Congress overrides, the courts reviews, this magnificent machine. And there's a reason for that, because the framers were fascinated with all kinds of pendulums and clocks and machines. It's a mechanical metaphor. But I don't care how exquisite it is on paper. It takes good faith to make the Constitution work. There must be a willingness on the part of each branch of the government to recognize the prerogatives and the competence and the responsibilities of the other. The Constitution is not automatic. It doesn't go on automatic pilot. It runs because you believe in it, because you understand it, because you support it, because you want it. That's the only thing that makes it work. There are constitutions all over the world, some of which are more eloquent than ours. They're not worth the paper they're written on, because the people don't believe in them. They don't care about it.
And perhaps because some other nations don't have an independent judiciary to enforce the Constitution, which has been a great gift to this nation, I think.
There's a difference in how we perform our function. The courts, and this is part of the check, speak in a language, they have a timeline, they have a discipline, an ethic, a tradition, a body of doctrine, the law, rules, stare decisis, that you are bound by precedent. We give reasons for what we do. We don't have a press conference to say what a great decision we made or how bad our colleagues were and how wonderful our dissent is. We don't do that. We have a language, an ethic, a grammar, a chronology, a tradition that's different from the political branches. It's not better, it's not worse, it's different. And part of judicial independence is that we speak this language that we call the language of the law. And we are not as flexible as the political branches. And we don't come down to the Supreme Court and say, oh, what am I going to do today? I think I'll decide a case on free speech. We don't do that. We wait till there's a case. We wait till two people are in disagreement, and in our case, until it's been argued in other courts. We can't just say, well, we're going to do this today. The Congress can, the President can. Again, there's a different dynamic. And that's very, very important for you to understand. And that's what, in part, justifies the three branches. And again, we're not better, we're not worse, we're different.
Justice Kennedy reminds me there's one other thing that I think we haven't mentioned, and that is that judges are bound by precedents. of this court, former decisions of this court, and of lower court of appeals judgments that have not been reversed or changed. They become part and parcel of the law. And over more than 200 years, believe me, there are lots of precedents out there, other judicial opinions at the appellate level that we have to follow unless there's a reason not to do so or they're overturned. And that's a huge body of law that also serves as a governance, a check on what judges do.
Does the selection of judges by a politician or a merit board make for a more balanced and less biased judiciary than if they were, say, directly elected by the people?
Well, your question touches really on state courts because the mechanism for selecting federal judges is set out in the Constitution, nomination by the President and confirmation by the U.S. Senate. But the states, the 50 states, have different ways of selecting judges. A majority of them elect judges in partisan political elections. And a minority of the states use some kind of merit selection procedure where judges in the state are appointed typically by the governor from a list of potential candidates submitted by some bipartisan commission. Now, I happen to believe that we get a better set of judges under merit selection than by purely political election of judges. But the states that have political election of judges like the system a lot and are not inclined much to change it in today's world. So we have both things going on. What disturbs me a little about the partisan election of judges is that candidates for judge typically will try to get some money for their advertising and their publicity in the campaign, and that money is most likely going to be given by the very lawyers who are most apt to appear before them. Now, maybe that's okay, but I think that poses some risks and dangers that I personally would prefer to avoid. But it's up to each state what system to adopt.
I underline Justice O'Connor's comments is the premise that this isn't going to change. Judges have a tremendous amount of authority and power in our system. And Americans want to keep some kind of a string on that power in the states. Now, we have some courageous judges in the state system that know that they make unpopular decisions, and because of this discipline of the law we talked about, they do the right thing. But I hope that we can take what is a serious problem and turn it into advantage. I hope that the citizens of the country, that the legislatures, that the bar associations, that the judges themselves will use campaigns to talk about what it is to be a good judge.
Now, considering the two cases, Georgia versus Cherokee Nation and Aaron versus Cooper, now in those two cases, in the former, President Jackson defied the court, but in the latter, Eisenhower supported the court's decision to integrate schools. What accounts for this change, and what, if anything, would this teach us about the rule of law and an independent judiciary?
You're quite right. In the 1830s, the court said that the land in Georgia belongs to the Cherokee Indians. It was their reservation. And as you said, President Jackson said, well, John Marshall, the Chief Justice, made his decision, let him enforce it. And he sent troops, and they evicted the Indians. And they sent them to Oklahoma, where their descendants live to this day. Those who survived, many died. And you're also correct that after Brown versus Board, the court said you cannot have segregated schools. And the governor of Arkansas said, I will. And he stood there with the state troopers, and all 9 judges signed the Supreme Court opinion. Well, you could have had 9,000. So what? He had the troops. So it was President Eisenhower who sent the paratroopers, who took the black children by the hand and walked into that white school. And the governor was stuck there because he didn't have the army. But Eisenhower did it, and he deserves credit for that. And what do you think about Bush v. Gore? What do you think about school prayer? What do you think about abortion? You think those aren't controversial? They sure are. And yet there are no people in the streets, and there were no troops called out. Now, what accounts for that? That's your question. I do know we fought a civil war on the question of whether you had to follow the law. I do know we went through 80 years of segregation, pretty bad experience. I do know the country's had its ups and downs. And gradually, I think people have come to understand that the rule of law is necessary. I mean, look around. We have 300 million people. We have every race, every religion, every point of view, and they have agreed to decide their disputes under law. It's like free speech. Free speech is not for the people you agree with. Free speech is for the people you don't agree with. But how tempting it is to say, oh, it's not for that, that's too wrong. Well, that's what it's there for. And similarly, a rule of law is there to bring us together when we don't agree. It's there even to enforce the wrong things. So you say, what's the answer? How did we get there? And I have to tell you, I have no magic answer. You and I are the beneficiaries of what other people have done. You and I are the beneficiaries of the brave children who walked into that school in Arkansas and the president who sent the paratroopers to help them.
And I like to think the difference is, and this is indicated, I'm sure, in Justice Breyer's remarks and his thinking about Georgia and comparing it with Cooper versus Aaron, that our democracy has matured. Over the perspective of time is a great teacher. And over the perspective of time, the American people have said, we are one people. We are Americans because although we come from different ethnicities, different religions, different national origins, we have something in common, and that's this thing we call the Constitution.
We do know that the rule of law offers the greatest opportunity we have to live in peace with each other and with the rest of the world. And that's one reason why this country has made so much effort to help encourage other nations around the world to also follow a so-called rule of law concept, where all of us in every nation are approaching problems in a similar way and under legal principles that can be enforced through the courts.
What do you think the greatest threat to an independent judicial branch is in this country at the moment?
I think the greatest threat is citizens who are unaware of what judges do or why
Precisely.
they should be independent, the nature of the Constitution. If people are aware of the job, they're likely to protect it.
I think polls of public opinion recently indicate that there is a profound lack of information about our system of government in our country and about the three branches and the checks and balances and even about what it is judges do. And so I think absence of knowledge in the public about what it is our system is and what judges do is a pretty big threat at bottom because people need to know and understand. But there are more specific threats at present. There are all kinds of allegations of judicial activism and a judiciary run amok, I think, is one turn of phrase I've heard. And the result has been a number of proposals in Congress to do various things, such as remove jurisdiction of the federal courts from certain types of cases, efforts to reduce funding for the courts in an effort to somehow punish judges for decisions that the members of Congress sponsoring it don't like. The establishment of perhaps an inspector general to review judicial behavior and see if there's something that needs to be brought to public attention. There are many proposals, and for impeachment for certain acts. So this is an area of concern today, and one which makes me even more anxious that the public know and understand what the system is and what it is judges do and what governs judicial decision-making. I think our time is up, and I want to thank you on behalf of all of us for your participation as students, and you made it possible to have a really very good conversation with you today. So, thanks so much.